Um, okay, so this is the first of what I'm hoping will be a series of interviews with folks who use the law to try and um, make a difference in the world and to make life better for those around them. And so our first guest is Huma Rashid, and I will let her introduce herself. So.
Hi, I'm Huma. Huma Rashid. I went to John Marshall Law School in Chicago. I've been a criminal defense attorney in private practice for about 7.5 years. And since July of 2020, I have been working as a mitigation expert and a clemency specialist for an American nonprofit.
And so what do you do in terms of, when you say a mitigation specialist and a clemency expert, what does that entail?
Okay, they are very closely related, but they're two different areas. So mitigation it's a fancy word for basically every good thing about your client that you can throw at the wall and get either in front of a prosecutor as part of a negotiation in the trial courts. So at the state or the federal level, or get it in front of a judge for a sentencing hearing following a trial or at a plea. Some pleas are the type where the plea agreement already says what the sentence is expected to be. So mitigation tends not to be as important in those cases because it's kind of been set in stone already, but for the judge's approval. But in a lot of cases, the judge gets to make the decision at sentencing, and you want to make sure that the judge has all the good information about your client. Now, this information can be used, it's usually done at sentencings, but it's also for other motions. Like, for example, right now, what we're doing a lot of is compassionate release motions. Those used to be for inmates that were elderly, that had very pressing family matters, that all those things that basically indicated that, hey, judge, this person has been in for a number of years. The interests of justice indicate that they should be let out, even though they're not done with their sentence. And so obviously you want to make sure the judge knows all the good things about that person. And right now, those motions are being filed more frequently just because the terms under which you can file them, they've been expanded greatly by the CARES Act and the pandemic. So we're
What
able to get a
what
lot
do
of
you
people
mean? What do you mean by the CARES Act?
Former Attorney General Bill Barr had put out a memorandum that said, because previously compassionate release was rather limited. It was limited to elderly and infirm inmates mostly. And if your client wasn't one of those things, you had a real uphill battle. But what a former Attorney General Bill Barr did was he said, in light of the COVID pandemic, if you've got inmates that are elderly at increased risk of getting COVID because of other medical issues, all sorts of things like that. If they have pressing family concerns, if they've served 50% or more of their sentence, then the BOP is instructed to screen for them and to let them out upon proper motion. So BOP did that independently. Um, for some people, they just kind of went through their records and they determined it and they let them out, usually on home confinement until, such time as appropriate. But for a lot of those people, because BOP did not do it automatically, their attorneys, whether public or private, had to go in with a compassionate release motion, cite to the CARES Act, and then the judges could make their decisions.
And BOP is the Bureau of Prisons. That's the federal agency that runs the prisons, right?
Correct.
Okay.
So
Um,
that is mostly the mitigation aspect of it.
okay.
And the clemency part is different. So clemencies exist on both the state and the federal level. At the state level, they're directed to the governors of each state. And that is when someone has been in prison for a certain amount of time. They still have a certain amount of time to go. You put a petition in front of the governor that says, look, please commute their sentence, let them out. And the governor can, make that decision. Closely related are pardons, which are a little bit different. Usually, at least at the federal level, all clemencies and pardons, they go to the president, obviously. So at the federal level for pardons, usually it's when a person has been already released for prison for a term of 5 years, then they can apply for a pardon. It wipes the conviction off the record and they can move forward without that, black mark on their record, so to speak.
Right. And In fact, you just had some great success here at the end of President Trump's term with clemency, right? Can you say a little bit about that?
I did. Historically, what generally occurs is that when the president is in the lame duck portion of his presidency, then that's when the real clemency push starts. And that was what happened this year. So shortly after the election, maybe mid-November-ish, I switched from doing mostly mitigation to doing all clemency work. And we worked with other nonprofits,
Mhm.
and they funneled us their names on their list. So basically, a lot of different agencies had a big roster of names, and we all split them up. And so we had great support staff. We had attorneys like me that would call up the incarcerated person, do typically I budgeted like an hour-long interview where I asked a bunch of questions about their life, about their reentry plans, about different mitigating circumstances. So I said clemency and mitigation were very closely linked. That's part of it. And then I wrote it all up, and it was assembled by the staff along with letters of support, disciplinary records, medical records, and all of it was funneled to White House counsel's office, the Pardons Division. We had advocates that met with former President Trump about once every 2 weeks. He met with his pardons attorneys pretty regularly. Believe it or not, I know that reports on this are conflicting, and I'll keep my political views out of it, but one good thing that President Trump did was he seemed to take the clemency and pardon power pretty seriously. And we've heard a lot of hubbub in the news about how people are paying $2 million for pardons and clemencies and all this stuff. President Trump, in the very early hours of the last day of his presidency, released a list that had about 75, I believe, pardons and 75 clemencies. And so I said that they were different. Pardons are generally for people who are out of prison, want that wiped off their record. Clemencies refer to commutations, where the person gets out of jail in the next couple days, like they're done. And I had submitted with, as part of my organization, 27 clemency applications since about mid-November, so mid-November till a couple days before the end of his presidency, and 8 of those people were on that list. So that means 8 people are walking out of prison, for federal prison for good.
And to give a little context, can you say a little bit about what a normal success rate would look like?
One of my
Um,
mentors, who has been a practicing criminal defense attorney for about 30 years, has had one person on the clemency list throughout his entire career. So the 8 was absolutely shocking. It's not completely unheard of, I don't think, but it's pretty close to it. It's an insane success rate. And I had a tip off from White House counsel's office about one person who was on the list. And I had a tip off about another person who sadly was not. So I'm not really sure what the circumstances were there, what happened. But the other 7, they were a complete surprise, and what a great one.
yeah, well, that's you are certainly, I'm sure, very justifiably proud of that accomplishment, and you should be. But what made you decide to get into this work, into doing this kind of mitigation and clemency work?
I'd been a criminal defense attorney for about 7.5 years, and that meant that I did a little bit of appellate work, but mostly it was all trial based. It was in the state and federal trial courts, and about 97% of criminal cases end up pleading guilty, at which point you've already got, a deal worked out, or you've got to convince the judge of an appropriate sentence. The other 3% go to trial, and a very, very, very high percentage of those end up in verdicts of guilty. So in a lot of cases, you're either doing what we call like a pitch, a mitigation pitch to a prosecutor to negotiate, or to a judge at sentencing, after a trial or at plea. So mitigation is still a pretty big part of trial work, because those are really the only 2 options. You either plead to something, and it's our job to negotiate what that something is, or you go to trial. And
Yeah,
even in that case, you either win or you're in the same position where you have to accept responsibility for something. And I realized that mitigation work was by far my favorite aspect of the job. I have a real good knack for getting to know people, for talking to them, and I say this humbly, but I've had excellent success in getting people to talk about their different traumas. And I say that with an understanding that it's very easy to be a trauma voyeur. as a criminal defense attorney, because we are with people during the most stressful parts of their lives. And sometimes, I mean, that's fodder for stories at cocktail parties, which doesn't really respect the dignity of our clients, you know? So you have to watch for that balance. But the reality is that we do talk to our clients about some of the worst things they've done, the worst things they themselves have experienced, and we have to present it. And you have to do that with dignity, you have to do that with compassion, but you also have to do that in a way that will maximize your odds with the prosecutors, with the judges. And that balance was very exciting from a professional level. It offers just such a chance to think on your feet, to, I mean, you have so much information coming in. You have to synopsize it and you have to be ready to expand on it. And you have to move fast. And when you get the results that you're hoping for, or even better, it's a huge rush because it is such a positive difference in that person's life. And it was my favorite part of the job. And so when I wound down my time in private practice, I turned my sights towards that. And I thought, you know what? I would love a job where I just did, you know, only that.
Sorry, I'm listening to you. I will admit I got a little choked up in hearing you talk about this because you're absolutely right in talking about you know, how important it is to ensure that the client's story gets told, but that it gets told in a way that you know, supports their dignity and their agency as human beings. And that's such an important aspect of the practice that I think so many people in that area, they may know it, but they can't necessarily articulate it as clearly as you did. And so I really appreciate that. Can you tell me a little bit about, you know, sort of how, you know, how you get motivated in the work day to day? You know, one of the things that's hard about the practice of law is that rewards are frequently deferred, right? You submit, you make your submission, and then it just goes into a black hole, you know, for, if you're, you know, for 3 months or 6 months
Mm-hmm.
or a year, or, you know,
Oh, yeah.
here there's a massive backlog of cases
Mm-hmm.
that runs for years. So, you know, how do you get motivated? You know, as you say, when you win, when you get the results you're looking for, it's a massive rush. But how do you get motivated when that rush won't come?
It's about keeping an eye on the big picture and keeping an eye on all the little details at the bottom, in my experience. And it's about broadening your definition of victory. That was the first lesson that I learned as a criminal defense attorney, that we look at qualified wins. Obviously, the win is not guilty, not guilty at trial. You know, you watch TV shows about lawyers and criminal cases, and the big win, the climax is, you know, the surprise witness at trial leads to a not guilty. The jury is shaking the defendant's hand as he walks out of the courtroom. The judge is clapping. And it's like, that's wonderful. Very, very, very rare. And I've certainly never heard of all those things happening. I'm sure they
I've never
have,
seen a
but
judge clap in my life.
mm,
I've never
um,
seen a judge clap.
if you're waiting for that kind of win, you're going to keep waiting. And if you're waiting for that to motivate you, you're going to keep waiting. And so you just have to, it's about learning that there are things that don't look like wins that really are. So if your client is exposed to jail time and you work out a deal with the prosecutor that gets them probation, yeah, that's a conviction on their record, but they're not spending a day in custody. That's a win. You know, if that was their goal, that, hey, you got to keep me out. I don't care what else happens. I don't care if I have to, you know, surrender my license or my gun or this or that or do community service, just keep me out of jail. When you do that, that's a win. Doesn't feel like it because someone's walking out with like a felony or a misdemeanor conviction. If you go to trial and you win one and you lose one, I mean, that's a win. It is, because you convince the judge or the jury that, you know, you convince them to that high level of proof that you know, they can't prove guilt beyond reasonable doubt. If someone comes in and they tell you about their problem and you say, look, I can't help you because that's not really, you know, that's not really a criminal case, that's this or that, but here's something to think about, and that person leaves your office feeling better than they did when they walked in, that's a win. And so For me, it's all about just gratitude and being aware of these things. And you can feel that gratitude when you learn to look at more things as wins, when you see the silver lining in things, when you can look back on your day, when you're, turning on your car to go home in the evening and think, 3 people talked to me today. They all hung up the phone or left the office feeling better than they did when they came in. Doesn't mean everything was fixed, doesn't mean everything was perfect, but today they had peace, and I played a role in that. As far as filing things and then you're waiting and you're waiting, that's true, you absolutely are. Some judges, few judges, are pretty good on turnaround time. Most are not. Like you said, you file it, it sits, you call the clerk, you're like, hey, I'm not trying to be rude, but can you look at this? Can you give me some date, something? And that absolutely happens. And that's why it's really important to make sure the pleading, the memo, whatever it was that you filed, you did a good job, because that's its own reward. You can look at that brief and you can say, man, I wish the judge would calendar it, but it's a good brief. I can't wait to argue it, you know.
Yeah.
Things like that. You have to find the joy. You have to find the pride where you can.
Yeah. Well, I feel like this next question has sort of been running through the whole conversation up to this point, but I'll ask it explicitly. So how does your work, how do you draw on the law to build what you see as a better world?
Building a better world means so many different things to different people. And there are big ways to do that, kind of like what I was talking about earlier. There are big ways to do that, sentencing reform, getting rid of mandatory minimums, getting clemencies, expanding the rules that allow us to get people out, to reduce the size of, the mass incarceration system, to reduce the power of and discretion of BOP, to give the judges more discretion with sentencing. Those are big, lofty criminal justice goals that I'm confident that we can achieve. But there are also smaller ways to make the world a better place. Saving one client at trial, with the not guilty. Keeping one client from being charged, just walking someone through a situation. So using the law, that's one of the things that, like, when I talk to, people who are considering law school, people who are in law school, and they talk about, the law. And the law absolutely is a very, static, codified thing that's in a bunch of books. It's the US code that we look at. It's the sentencing guidelines. It's, the committee notes from Congress. It's written down black and white. It's in a book. We have to look it up and research it and think about it. But so much of the law is dynamic, because you're not just dealing with the law. You are dealing with personalities. You are dealing with your client, who is a unique person with their own set of goals that you, for all your education, for all your schooling, for all your experience, might not know without talking to that person. You're dealing with prosecutors who have their own opinions and thoughts that you have to overcome. I've had prosecutors that said, like, I understand drug crimes. A lot of those come from addictions, from injuries. Like, I understand that. I do good deals on that. But man, the second a person picks up a gun, I just, that's it for me. I just think that they're right on the road to being a criminal, and there's no coming back from that. Well, guess what? I have to get them to back down from that. You're dealing with the personalities of judges. All of these things are very dynamic, very, very much in flux, and as big a part of the equation as the law itself, because you have to manipulate all those things to get a good result. So it very much matters to know the law, to study it, to be able to use it when you need to, but you also are playing to an audience. Every single second of what you do, you're playing to an audience. I can have the best case law in the world, but if I don't reach the judge, if I don't move him with some example, with something, I mean, am I maximizing my client's chances? No. So I think part of using the law to make a difference is keeping an eye on how you can do that in big ways and how you can do that in your day to day. And there are always ways, there are endless ways to do that.
Yeah. No. I think that's such an important thing, right? The notion of that law is fractal, right? And so there are things that we do that are playing on a very big stage and that affect a lot of things all at once. But then there are things that we're doing, client by client and case by case and judge by judge. And you're absolutely right in that it's as much about relationships as it is the sort of larger the black letter stuff that we teach the law students.
Mhm.
So, with that in mind, right, thinking about that and thinking about as you talk about the relationships that you draw on and the audiences that you play for, how do you sort of draw on your own sense of empathy when you're doing your work? You've talked some about how you use that to draw from your clients, and also you've talked a little bit about how you use it with prosecutors and judges. Can you expand on these things just a little bit, and maybe, if you're comfortable, certainly we'd be delighted to hear some examples.
Of using empathy.
Sure. Yeah. Yeah.
One of my favorite examples was it was October 2019, and I was arguing for the first time in front of the Seventh Circuit. And that is the appellate court that, oversees at the federal level, Illinois, Indiana, a bunch of other states like that, just in the Midwest, Wisconsin.
Mhm.
And it's a grand courtroom, very ceremonial in the Dirksen building in Chicago. And it was my very first, not my first time observing, because I've had the chance to observe before. Um, it was my very first time arguing in front of them. And it's a very imposing panel of 3 judges. Mine happened to be all elderly white men, very skilled, jurists, just so intelligent, very intimidating. And I was the first one on the list. So I didn't have the benefit of sitting there and watching 5 other attorneys, kind of warm up the room a bit. The court was called to order, and then my name was called. And so that was
Yeah.
it. Um, and I had a client where it was a case of the argument was double counting under the Career Criminal Offender Act. That it was not a super strong argument. There might have been something there, but it was not the one, that I expected to win. But this was an elderly Black man who had lived all of his life in East St. Louis, which is a very, very dangerous city. It is right on the Illinois side of the Mississippi River, right before you get to St. Louis. Very dangerous. He had gone to the bar. He had he had gotten drunk. He was driving home, realized he was a bit too drunk, pulled off and fell asleep. And of course, the troopers saw this car kind of half on the shoulder, half in the lane. It's cop magnet. So he pulled over and he walked up to the window, and my client was asleep, and there was a loaded gun in his lap, because it's a dangerous city. If someone surprises you in your car, I mean, I'm not going to debate with anyone who's not in that situation or aware of
Right.
it, like the wisdom of having a piece there.
Right.
Maybe not in your lap when you're drunk and asleep, but that's what the situation was. And he was unfortunately a felon, so he was not allowed to have that weapon.
Mhm.
Um, but again, a thing that you learn when you deal with people from all sorts of walks of life is that the choices that you think should be made might not be the choices, certainly they're not the choices people make. And in a lot of cases, they're very understandable. So he was charged with that, and at sentencing, he tried to argue to his judge during the allocution, where the defendant speaks to the judge. He tried to say, "Look, judge, I've been in and out of prison before. Like, you're looking at 188 or 180 months. Like, can I have less? Blah blah blah." The judge took that as disrespectful. This was a white judge, very well educated, legacy, a big name in Southern Illinois and Central Illinois. I believe one of his forebears was Lincoln's law partner. So that tells you
Right.
something.
Right.
Um, and this was an uneducated older Black man. And their experiences, I'm sure you can imagine, were very different. And so while, my client thought he was speaking, the judge interpreted it as yelling, took away his acceptance of responsibility points, which added 8 months. It went from 180 to 188. I was there to argue that that was wrong. It should go from 188 down to 180. And so Judge Easterbrook was on my panel.
Ooh. Whoa. I
It was
when
Judge
you when you
Ripple, Judge
oh,
Hamilton, and Judge Easterbrook.
oh,
And
oh
I mean, you
God.
guys
The
can
only
see
thing that would be worse would be if you had had Judge Posner.
he was off the court at that time, but and you guys can see what I look like. I'm 5'1", and I look relatively young, and I'm standing there alone, and I've got a tall white, male AUSA right next to me, waiting for his turn to argue. So
The
Judge
AUSA is the prosecutor, the Assistant United
Correct.
States Attorney.
Correct. He was the prosecutor at trial. Sometimes they get to do the appellate argument, sometimes they don't. Usually they do. So he was standing there very patiently waiting for me to finish so that he could do his thing. And So Judge Easterbrook, he'd been silent the whole time. And then he piped up and he's like, well, counsel, he didn't even bother touching the Career Offender Act because we knew that was a dead end. We knew that was a dead end. But he said, counsel, even if we give you what you're asking for, that would result in a reduction of 8 months, right? His point being, you're asking me to go down from 188 months to 180 months. It's still a long time in prison. What are you doing?
Yeah.
And at the appellate court, it's a very formal environment. You're focused on case law. You're focused not only on the case law you're arguing, but how it got there. So the evolution, all, the progeny, how other circuits interpret it. Attorneys carry binders with notes and cases and stuff so that they can refer to it. I had stepped up with 4 index cards.
Mm-hmm.
And so that was what he asked me. And the temptation, of course, would have been, let me look at the case law. Let me say, well, Judge, in this case, the Seventh Circuit 15 years ago said this, and the Supreme Court, said that, and then this circuit interpreted as this. And I just looked at him, and I understood, like, the academic bent of the question, like, that the legalese part of it. But bringing it back to empathy, I looked at him and I was like, what is he saying? He's saying, counsel, you're quibbling over 8 months when this guy has, more than 10 years, 15 years to serve, that he just started like a year or 2 ago. He's going to be in there for a long time. You're coming to me for 8 months? I looked at him and said, well, Judge, 8 months is 8 months. 1 month is 1 month. And 1 day in custody versus 1 day out of custody is precious to anyone who's in there. My point being, I'd come to you and I'd ask you for 1 day off his sentence. Like, that's a big deal. And I remember I caught Judge Hamilton's eye. He was right in the center and he was writing his notes, which they always do. You can't read too much into that. But when I said 1 month in versus 1 month out, 1 day in versus 1 day out of custody is precious, he looked up and he nodded. And so I wasn't speaking, in my mind at least, as an experienced Seventh Circuit practitioner. I was speaking as, a quick and dirty trial attorney at sentencing, making some argument and hoping that it would hit, just the emotional aspect of it. And it worked because I won that case.
I remember you talking about that, and yeah, that's, now that I don't think you've ever told me the whole story, and now that I've heard it, I see why you are so proud of that case.
Because it wasn't focused on the law in the books. It was focused on this man who's not even in this room because he is serving out the next 15 years of his life in custody. Yeah, 8 months matters to him. It might not matter to you because, you're a justice on the Seventh Circuit and you see all these cases all the time. It might not matter that much to me because I'm going to lunch after this. I'm not in custody. But to someone who is in custody, it matters a whole hell of a lot. I mean, if you're like my clients who the 8 of them who won clemency, if they're told, you're getting out at noon, but then they got to wait until 5 o'clock, those 5 hours are precious. Whereas it's very easy to say, oh, come on, what are you fussing for? You got clemency, the president signed your name, Ivanka called you up and herself, 12 noon to 5 p.m. Come on. But no, those 5 hours mean something.
Yeah.
I mean a lot.
And I think that that's such an important aspect for us as attorneys to remember, that, I say this all the time, but I don't think I've ever seen it, I've ever felt it illustrated quite so clearly as you have today, that, for our clients, this is the most important thing that's happening in their lives.
Mm-hmm.
And for us, it's Tuesday.
Right.
And
I got a trial starting next week. Like, I got to get through this argument so I can prep it. That's exactly how it is.
Yeah.
Unless you kind of try to stop and think and pause and do the task. And then, yeah, regretfully, you have to move on to doing that for the next one. But you're right. For them, it's the most important thing.
Yeah. Well, Huma, I really appreciate you taking the time to talk to me. You've really, I asked you to do this because I admire you, and now I admire you so much more. So I really appreciate you taking the time to chat with me about this, and this is certainly this has been a really precious half hour for me as well. Um, and what I'm going to do now is I'm going to take this recording and I'm going to put it up on YouTube. If you want, I will sort of hold it back until you've had a chance to look at it and make sure that there's, if you want me to pull it back and maybe do some editing, I'm happy to do that, but I
That's
would need
fine.
so and then I'll send it out to my students and probably uh, um, post it on Twitter and be like, hey, look at go and look at all the cool stuff that Huma is saying. So thanks so
Sounds
much.
great.
So
Thank
all
you for
right.
having me. I really appreciate it. There's
No.
room for, for all of your students, there's room for anything that they want to do within the law. Really, there is.
Yeah.
We hear so much and we see so much, on TV with like the fancy lawyers in their office working on mergers and transition, like all this stuff. And it's like, yeah, that's one aspect of it. Anything you want to do, if you want to be in court, if you want to be in court for corporations or for people or for policies, if you want to be lobbying the president for reform, if you want to, be standing up as part of legal aid, if you want to help people find their dream house, if you want to advise only and never go to court a day in your life, that's great too. There are so
Yeah.
many ways to help.
Yeah. Well, I appreciate this and thank you so much. And I'm going to stop the recording now.